Hey everybody, welcome back to the Court of Random Opinion. My name is Lauren Neidigh. I have another quick update for you in the Justin Baldoni versus Blake Lively legal saga. An objection to one of the New York Times motions by Justin Baldoni and the Wayfarer parties hit the docket this afternoon. Luckily, it's not too long, so this won't be like a huge long update. But I am gonna read these documents for you just so you know what's going on. If you missed my short live stream earlier, it was only about 5 minutes. The judge set a conference for this coming Thursday at 10 a.m., and it is going to be publicly available. So I'll be streaming Thursday at 10 a.m. We'll have the audio of that conference, and we'll be able to talk about that in real time. But tonight we're going to go over the motion or the objection to the motion for stay of discovery by the New York Times. Now, the New York Times, they filed their motion to dismiss Justin Baldoni's complaint on Friday. And this motion to stay discovery, I think you guys probably saw if you were watching that stream, you saw my brain breaking in real time because they filed so many things at once. And I had waited all day for one thing to appear on the docket. And I was like, oh my gosh. So I kind of overlooked this motion. And then when I saw the objection, I was like, oh, okay, I got to go back and read that. I'm just going to wait for a couple more people to filter in here before we get started on reading these documents. Don't worry, like I said, they're not too long. But if you guys don't know, a stay of discovery, it would mean like they're pausing kind of the gathering of evidence. And we'll get into their reasoning for that in just a second. So we'll go over the 3-page New York Times motion first, and then we have a 4-page objection from Justin's side. But yeah, when they first made that motion to stay discovery, I barely even noticed because my brain was just frying, and not like a delicious fried. It was like a ant under a magnifying glass fried. It was not good. So I'm feeling much more rested today, though, somehow, even though I was streaming until like 2 a.m. or something last night. We went up over that publisher's crazy ass lawsuit, Stephanie Jones. So. All right, let's get started, shall we? Hey, everybody. Hey, Winks. Thanks for joining. Okay, I want to make sure I get these in the right order. Yeah, here it is. Hopefully you guys can read that. If not, just let me know and I'll try to zoom in a little more, but okay. Dear Judge, this firm represents consolidated defendant, the New York Times Company, in the above referenced action. Pursuant to Local Rule 7.1d and paragraph 1c of this court's individual practices in civil cases, we write to respectfully request that the court enter an order under Federal Rule of Civil Procedure 26c, staying discovery as it relates to the Times until after the court has decided the Times motion to dismiss, filed contemporaneously herewith. Notwithstanding this request, the Times will provide initial disclosures by March 14th, 2025. So they want the judge to rule on the motion to dismiss before they, go through the process of providing any evidence, basically. So that's interesting. But all right, at a hearing on February 3rd, the court set a deadline of August 14th for the end of all fact discovery. The Times had not yet been served with the first amended complaint before that hearing and was not in attendance. So I got the transcript for that hearing last week, and they were not in attendance. They did not have a representative in attendance to my recollection. However, they may have actually been served with the lawsuit. So that's interesting. Or maybe it was like right after that conference. I'm not sure. I'll have to go double check that. At the time, the court remarked, as to the New York Times, it's not unusual for parties to be added in. I would hear from the New York Times once they have been served. Okay, so they hadn't been served yet, but the amended complaint had been filed, but it hadn't actually been served to the New York Times. Okay. It may result in the case management plan being changed, but at least the parties can get going. In this letter, the Times seeks to take the court up on its offer to ask to alter the case management plan. The Times has not previously requested a stay of discovery. Defendants/consolidated plaintiffs do not consent to the Times request. All other parties consent. There is good cause for the court to grant the Times' requested motion to stay. Upon a showing of good cause, a district court has considerable discretion to stay discovery pursuant to Federal Rules of Civil Procedure 26c. And you guys know I'm not a lawyer, so I don't go over a lot of this case-related stuff. I just kind of go through the meat of the documents. However, we'll read this one. In considering a motion for a stay of discovery pending a dispositive motion, a court should consider the breadth of discovery sought and the burden of responding to it, as well as the strength of the underlying motion. That's kind of interesting because I don't think anyone has actually tried to ask for anything. So how would you know about the breadth of discovery? I don't know. That could just be a legal thing I don't understand, guys. But it sounds weird to me. Okay. Here, each of these factors supports granting the Times request. First, a stay of discovery is warranted given the clear First Amendment implications of this defamation action. New York courts have repeatedly recognized that a defamation suit may be as chilling to the exercise of First Amendment freedoms as fear of the outcome of the lawsuit itself, and that courts should, where possible, resolve defamation actions at the pleading stage. Okay. For this reason, court in this district frequently find that there is good cause to stay discovery in defamation matters. Okay. In fact, just recently in Flynn v. Weissman, the court granted a stay in a defamation action because defendants made a strong showing of, among other things, the burden they would face if discovery were to proceed. The First Amendment issues in this case favor a stay here too. Okay. Second, a stay of discovery is appropriate, whereas here the motion appears to have substantial grounds. The Times motion, which offers numerous independent grounds for dismissing plaintiff's First Amendment complaint, is meritorious. First, as the plaintiff's defamation claim, because the article reports Blake Lively's California Civil Rights Department complaint against Justin Baldoni and others, it is absolutely protected under New York's fair report privilege. And there were a couple of attorneys that I saw going over that this morning, the fair reporting thing, so that you might want to check out those channels just to hear what they had to say about, was this really fair reporting? I can only speak from a layperson's opinion. That's why this is the court of random opinion, because I don't know if it was legal of them to do what they did, but I do know it was scummy. I do know it was garbage behavior. So I don't know. You can tell me that's just how the news media works or whatever, but it's still trash. I don't care if that's just how it goes. That's still trash. So that's just my thought. So, but as far as the legal system goes, I don't know. The article is additionally non-actionable because the only challenge statement is non-actionable opinion, and because the FAC is a First Amendment complaint, does not plausibly allege, as it must, that the Times acted with actual malice. The complaint should also be dismissed. This isn't a motion to dismiss, kids. What are you doing? The complaint should also be dismissed because it fails to adequately differentiate between the purportedly tortious conduct of each individual defendant, a clear example of group pleading, impermissible under Rule 8. Next, the Times motion to dismiss the false light claim is also likely to succeed because New York law applies to plaintiffs' claims, and New York law does not recognize the false light tort. Finally, the Times motions will also likely result in the dismissal of plaintiffs' breach of implied in fact contract and promissory fraud claims. The contract claim fails because plaintiffs have not plausibly alleged a breach, which is a foundational element of the claim, and the promissory fraud claim fails because it is premised on the same set of facts as, and is therefore redundant of, the contract claim. In short, the strength of the pending motion favors a stay of discovery. Third, discovery in this case is likely to be far-reaching, expensive, and wrought with complications. Okay, I feel like we might be making a leap there. Is it possible we're making a leap there? Because, like I said, I don't think anyone's been asked for anything yet, but okay. Several of the parties in this action have already sought the issuance of at least 19 subpoenas seeking, for example, call logs and documents. Now, who was that? Call logs and documents reflecting the communications between various parties and non-parties, and have served at least 10 other document requests. To the extent plaintiffs or other parties seek the same kind of extensive discovery from the Times, it would not only require the Times to undertake the financial burden of document collection and production, but also require the Times to litigate complicated issues related to confidential sources and the application of New York's shield law. Particularly given the strength of the motion to dismiss, this burden is unnecessary. Okay, but like I said, I don't think anyone's actually tried to serve anything on the Times. It's just been between the other parties. Not that they won't, but if we got any lawyers in the chat, please weigh in on that. Let me know what you think. Wait, this is the New York Times, right? Yes, correct. So this is the New York Times asking for a stay of discovery, and then we're going to read Justin Baldoni and the Wayfarer party's response to this. We're almost done with this document here. Okay. Fourth, a stay of discovery would not impose undue prejudice on the parties. A delay in discovery without more does not amount to undue prejudice. Okay. This is particularly true where, as here, other parties to this action are already exchanging documents and can proceed without burdening the Times, which was served with the first amended complaint just this month. Indeed, despite other parties having sought extensions, their Rule 12 motions, the Times has responded within the 21 days provided for in the federal rules. Moreover, the requested stay is for a short period of time, since the Times motion will be fully briefed and ready for a decision by March 24th. And that's 3 weeks from today, guys. Based on the foregoing, the Times respectfully requests that the court issue an order staying all discovery of the Times until the resolution of its motion to dismiss. Notwithstanding the foregoing, the Times agrees to provide initial disclosures on March 15th. In the alternative, if this court denies the motion to stay, the Times requests the court extend the discovery schedule by 1 month because the Times entered the litigation later than the other parties. Okay. So that was filed on Friday, the February 28th. And this is their response, which was just filed this afternoon. Very comments, Sharon. Hang on. They're going to have to settle because they don't want this in the hands of a jury. Ah, interesting. Hey, Anna. How's it going? If I recall correctly, I think Anna here in the chat is a lawyer or some kind of legal professional. Please correct me if I'm wrong, Anna. But she may be able to answer some questions for you guys. That was from the New York Times. And then this is the response from Justin Baldoni and the Wayfarer parties that we're about to read right now. Okay. Dear Judge, as counsel for Wayfarer Studios, Justin, you guys get the gist there. We object to the New York Times Company's request for an order pursuant to Federal Rule of Civil Procedure 26C, staying discovery as to the Times pending a determination of its motion to dismiss. Pursuant to Rule 26, the court has discretion to issue a protective order on matters relating to discovery upon a showing of good cause. Okay, here it says the burden of showing good cause for the issuance of a protective order falls on the party seeking the order. To establish good cause under Rule 26, courts require a particular and specific demonstration of fact, as distinguished from stereotyped and conclusory statements. Okay. Discovery should not be routinely stayed simply on the basis that a motion to dismiss has been filed. And this is rejecting contention that discovery must automatically be stayed pending a motion to dismiss. A court determining whether to grant a stay of discovery pending a motion must look to the particular circumstances and posture of each case. Courts should consider multiple factors, including the breadth of discovery sought, the burden of responding to it, the prejudice that would result to the party opposing the stay, and the strength of the pending motion forming the basis of the request for stay. None of these factors weigh in favor of staying discovery as to the Times. You're a tax attorney. Oh, okay. Cool. All right. Okay, the cat lady says, Lauren is so on top of this case, literally the fastest creator. Man, I live in this docket now. This is where I live. All right. First, the Times has not demonstrated that the discovery sought from it will be voluminous or burdensome. I think that's kind of what I was just saying when we were reading that. The Times allegation that discovery in this case is likely to be far-reaching, expensive, and wrought with complications is based upon pure speculation. Indeed, here we go. No discovery demands have even been served upon the Times by any party to this action. Furthermore, to the extent that the Times is concerned about requests for call logs and other extensive discovery, we note that such overly intrusive discovery was sought by the lively parties, not the Wayfarer parties. Guys, I feel like I'm finally starting to catch on to some of this stuff because this is like exactly what I was saying when we were reading the other document. We note that such overly intrusive discovery was sought by the lively parties, and this court, in granting the Wayfarer party's recent motion to quash certain subpoenas, advised the lively parties on how to appropriately narrow their discovery requests. In any event, Given that Ms. Lively alleges that the purported negative media campaign did not begin until approximately August 2024, coupled with the fact that the Times article concerning the alleged smear campaign was published in December 2024, the relevant period for any discovery sought from the Times is extremely narrow, thereby undermining any claim of burdensomeness. Burdensomeness. That's a burdensome word. Oh my gosh. Couldn't you just say burden? It doesn't matter. I should have this conversation with myself later. The Times' argument that it should not be compelled to litigate complicated issues relating to discovery is unavailing. If that was the standard, then virtually no discovery would proceed in any case with a pending motion to dismiss. Moreover, even if the Wayfarer party's claims against the Times are dismissed, which is unlikely, the Times will remain a critical percipient witness as it relates to other claims herein and will accordingly remain subject to similar discovery obligations as a non-party. Okay. In sum, the Times' conclusory allegations are insufficient to establish that it will be unduly burdened by discovery. And then here's a case they're citing. It says, denying stay of discovery pending motion to dismiss where defendant did not explain why plaintiff's discovery demands are voluminous and burdensome, and did not identify any burden associated with the production. Okay. Second, the Times has failed to establish that the Wayfarer parties will not be unfairly prejudiced by their request for a stay. While the Times contends that the requested stay is for a short period of time, the Times cannot predict when the court will decide the motion to dismiss. Most likely, a stay of discovery as to the Times will significantly disrupt the deadlines set forth in the case management plan and scheduling order. As it stands, fact discovery is scheduled to be completed by August 15th, less than 6 months from the date of this letter. Even assuming the Wayfarer parties are not unfairly prejudiced by a stay, that alone is insufficient to stay discovery given the other factors weighing against a stay. Third, the Times has not made a strong showing that the Wayfarer parties' claims are unmeritorious. As part of the merits analysis, courts have also considered whether a pending motion to dismiss will dispose of the whole action. And then here they're citing a case that says, on the first factor of the merits of plaintiff's claims, courts tend to consider whether the resolution of the pending motion to dismiss may dispose of the entire action. Okay. Here, other than the Times, there are a dozen parties who will remain parties, and the Wayfarer parties do not presently intend to move to dismiss. Ms. Lively's claims, so they're not going to file, I guess, a motion to dismiss Blake's lawsuit. Or presently they don't plan on it, I guess. Interesting. Therefore, the Times motion to dismiss will not dispose of the whole action. Additionally, when an assessment of the merits of a plaintiff's claims involves a fact-intensive analysis, such as choice of law assessment, courts have declined to conclude that a plaintiff's claims are unmeritorious. Ms. Lively's amended complaint contends that California law applies to her claims against the Wayfarer parties. The Wayfarer parties' claims, including against the Times, are asserted under California law. In its motion to dismiss, the Times contends that New York law applies to the claims against it and concedes that the laws of California and New York conflict for some of the claims. Given the choice of law analysis the court must undertake to decide the dismissal motion, the court should decline to stay discovery for this reason alone. And then C. Morales versus Next Stop, denying stay of discovery because court could not conclude that defendants have substantial arguments for dismissal, given defendants' motions to dismiss invoke choice of law principles. Okay. Even if New York law were determined to apply to the defamation claim, the court cannot determine, as a matter of law, that the state's fair report privilege applies because it is for the jury to decide if the context in which the statements are made makes it impossible for the ordinary viewer or reader to determine whether the publication was reporting on a judicial proceeding. I remember that when we were reading the motion to dismiss. Okay. Although the Times argues that its article merely reports Blake Lively's CCRD complaint against Justin Baldoni and others, and thus purportedly is absolutely protected under New York's fair report privilege, the Times dismissal motion acknowledges that the article went beyond reporting. Here, the article lays out in great detail the factual basis for its conclusion that plaintiffs engaged in a smear campaign against Lively. The amended complaint thoroughly alleges why the article is not a substantially accurate summary of the administrative complaint. For good measure, the Wayfarer parties intend to seek leave to amend their pleadings to remedy any defects therein that might otherwise support the Times motion to dismiss, such as impermissible group pleading, which weighs against a stay of discovery. We respectfully request that the court deny the Times motion for a stay of discovery. At a minimum, document discovery with the Times should proceed, and the court should stay that party's deposition only pending its motion to dismiss. Okay. AKA the cat lady says, very interesting. So they're witnesses regardless if the invitee lawsuit is dismissed or not. Yeah, I mean, they'll probably, I'm sure that they will be, but it sounds like that's what's going on. Sue D says, every time I go out and walk my dog, I come back to another of Lauren's videos on this case. Thank you very much. I appreciate that. Yeah, thanks everyone for being here. Definitely. Anna Fan, thank you for the $5. Your biggest supporter, Anna Fan, tax attorney. Hey, man, that's cool. Thanks. I appreciate you. Yeah, Anna's always here in the chats and everything, and she seems like a smart person. So, give me 1 second here, guys. So remember that the judge is going to rule on the protective order motions on Thursday during that 10 a.m. hearing. I don't know how long that conference is actually going to be. I'm not sure. When I looked at the transcript from their last conference on February 3rd, it was about 60 pages, but I don't know how long they were actually sitting there talking back and forth. And if you haven't read that yet, you definitely should, because there's some funny stuff in there. It's pretty funny. All right, guys, here's what's going to happen. I've got to send you over to my friend Brad right now. Because I'm done reading this document, but I'll be back with you very soon. Oh, AKA the cat lady, thank you for being a member for 3 months. Make sure to check out Justin's engagement video. It's beautiful. Oh, I will. Okay. All right. Thank you, everybody. Cover the Luigi Mangione case. Yeah, I'm gonna get on that. I covered this crazy ass sovereign citizen case that was filed here in my hometown in Florida, where they were trying to sue like the government and a bunch of other people for like billions of dollars and to free Luigi, and it was just like a nutty lawsuit. It was insane. So that was a pretty funny one, but I will actually cover the actual case. I just have to find some time to sit down and kind of get some stuff together. So okay, guys, please send my friend Brad lots of bacon emojis and robot emojis, because this is the bacon bot army, and I appreciate you. So I'll see you guys very soon. I'm actually gonna record something on Casey Anthony tonight, because Casey Anthony is now trying to become a TikTok influencer, and somebody needs to roast her. So I volunteer as tribute. All right, guys, say hi to Brad. Tell him Lauren sent you. Lots of bacon bots in the chat, and I will see you all very soon. Bye.